Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today's the day I earned that subscription. For today's story, we're going to go over the potential Trump indictment that has been in the news and try to go over some of the legal issues that are in play and try to talk about at least why some of this seems like it will be difficult for New York to prove. So let's go through the basics. What is going on? Well, this all seems to be relating to the 2016 campaign. All right, so the relevant time period is the 2016 campaign. Donald Trump is running for president. And while he runs for president, one of the things that he does is he pays hush money to Stormy Daniels. He uses Michael Cohen, who is his attorney at the time, to pay this money as part of a non-disclosure agreement. Now, the allegation isn't that the hush money in and of itself is illegal, because it's not. It's a non-disclosure agreement. You know, I give you money, you give me silence. That's a contract. We're both giving something we didn't otherwise have to give. So the problem isn't that the hush money itself. The problem, apparently, according to the state of New York, is that this money was not correctly reported. The money was reported essentially as a personal expense when it should have been reported as a campaign expense. So to properly understand this, it might be helpful to understand a little bit about the difference. And if you just think about the campaign as just being a kind of business and think about it as a business expense, you basically have the right idea. It's important when you're running a business to segregate properly money that is a business expense and money that is a personal expense. And if you conflate the two, you can run into all kinds of problems. And people sometimes have incentives to report something as one thing or another, right? Your incentives to report something as a business expense when it's personal is, right, well, now it's no longer your money that you're spending, and now it's the company's money. So it could be kind of an embezzlement thing. It could be a tax thing, you know, trying to avoid it being on your personal taxes or the corporate taxes. So it could be that kind of thing. And also the other way around, right? The reason you might want to have a business expense listed as a personal expense would be for similar reasons. Tax reasons, you know, it's no longer on the books of the business, or the business looks healthier than it might otherwise be, right? This $100,000 expenditure or whatever the money is, $1 million expenditure, whatever it is. If it's not on the corporate books, then it looks like the corporation didn't spend that money. So maybe the corporation looks healthier than it is, looks like it's not burning through as much cash as it otherwise be. That could obviously be used to mislead investors. It could be used to make the stock price artificially higher. It could be part of a whole bunch of reasons. So there are reasons that a person might want to list a personal expense as a business expense. And there are reasons a person might want to list a business expense as a personal expense, right? It kind of works both ways. And to properly make sure the money is on the right books for all these reasons, it's important to keep separate which is which. So the problem, according to apparently the problem to the state of New York, is that this was listed essentially as a personal expense rather than as a business campaign expense. This is a problem because if it were on the campaign books, it would have to be reported as part of the campaign expenditures. That would require certain reporting requirements. It would also require a certain paper trail requirements. It would also have to be part of the campaign, and someone might notice that it's on the campaign books and wonder about why it's on the books and ask questions. So maybe he was doing this to hide it from the campaign assets or campaign liabilities so that he would have an easier time running for president. This is sort of the generalized idea that the state of New York seems to be experimenting with. All right. So the state of New York has been investigating this for some time, and there's a grand jury in place, which looks like it's wrapping up very soon. Probably not an indictment coming down today, but probably if something's going to happen, probably going to happen pretty soon. It looks like the grand jury is wrapping up. So if not today, then later this week or next week or soon, but probably not today. And the charge that we would be trying to charge him with is basically this campaign finance violation. Now, New York has a bit of a problem in trying to lay these charges because of its own statute of limitations. Every state gets to define how long you can charge someone with a crime for. And most states have limitations on most crimes. Of course, murder being a notable exception to that, and other like first-degree felonies, top-level felonies. But most other crimes have limitations. So the first thing we might want to charge Trump with is improper record keeping, falsification of business records. The problem in New York is that to do that, it would be a misdemeanor, and the statute of limitations on a misdemeanor is 2 years. So that, 2016 was more than 2 years ago, so that doesn't really work. All right, so how about not falsification of business records? How about a state-level campaign finance violation? Well, the problem there is that under the relevant law in New York, the statute of limitations for that particular felony would be 5 years, and 2016 is more than 5 years ago. So that doesn't really work. So what New York appears to be experimenting with as an idea is an idea that I don't know has ever happened or been tried before. They want to say the problem isn't that you violated New York's campaign finance law. The problem is that you violated the United States government's campaign finance law, and that in and of itself comprises a violation of our law, basically. So we want to use the apparent violation or alleged violation of federal finance law, federal campaign finance law, and we want to use that as a basis for a state-level law violation in New York. This kind of legal theory has never really been tried before. The state of New York is a separate legal sovereign from the United States government. It would be like the state of New York saying, because you violated the law in Florida, that in and of itself is a violation of our law in New York. That's not really a thing that exists, right? If it violates Florida's law, then, talk to Florida about it. But because you violated Florida law, you violated New York law isn't really a thing that normally is done, ever. And New York is trying to do essentially that because the federal government is a separate sovereign relative to New York, just like Florida is. And it's like, because you violated the federal campaign finance laws by failing to report it properly, it is a state level violation and we can get past our own statute of limitations. This is a problem. This is a problem. So the legal theory is problematic. And then, of course, so that part of the legal theory is problematic. You violated the federal law. And so far, the federal government has declined to prosecute on this issue a couple times. If it were a violation of federal law, you would think that the U.S. attorney or someone else would be looking to bring charges, but they've all declined. So the sovereign whose law you principally violated is not interested in this. So that's an interesting thing. The other thing, of course, is that the other problem is, on the legal theory, is the idea that this is itself actually a campaign expense. See, none of this works as a legal principle at all unless it is a campaign expense. If it's actually a personal expense, then the expense was reported properly. So you first have to, of course, conclude that this actually is a campaign expense, which isn't inherently obvious because Trump has paid other amounts like this to other women at other times, at times when he wasn't running for president. So, and those were personal expenses, presumably, because how could they be campaign expenses when there's no campaign? Doesn't really quite make sense. So the other ones are personal expenses. But this one is really a campaign expense, which I suppose is possible in the first instance. I mean, just because all the other ones are personal expenses doesn't inherently require that this is a personal expense too. But you, of course, have to prove that it's not. You have to prove that this is the exception to the pattern. The other ones are personal, but this one isn't. Okay, that seems problematic. And then, of course, the other problem is that you have to prove that Trump had knowledge awareness, intent to commit the violation. That Trump didn't merely say, to Michael Cohen, just pay Stormy Daniels off. Here's some money. Because that's not enough. It's not enough that he paid her off. That's not enough. You have to prove the campaign finance violation. You have to prove that the money was falsely reported. So you don't have to prove the money was paid. You have to prove that it was falsely reported on the books, and that Trump knew it would be falsely reported on the books. So that Trump knew this was really a campaign expenditure, and knew that this would be falsely reported as a personal expenditure, and knew that that would occur. This seems very, very difficult to prove. This seems very, very difficult to prove. That all those things. So you've got all kinds of problems with this on legal theories. You have to somehow bootstrap your way into a New York cause of action based on a federal violation, which is strange. So you have to bootstrap yourself into this. You have to prove that this actually was a campaign expense. And you have to prove that Donald Trump knew that this would be falsely reported as a personal expense and was trying to obtain that result. And that all seems very, very difficult. So I have a lot of doubts going into this, to be quite honest, about the whole thing. Because I don't know. And of course, it's a couple years old at this point. So, people, trying to get records and trying to get evidence against it is also a bit problematic, because it happened a couple of years ago, which is one of the reasons that they wrote the statute of limitations in the first place, because they realized that evidence goes stale, and evidence has gone stale. So I think it's really, really troubling. And I don't know, I don't know that this case they may well indict, but I don't know what happens after that, because I have a lot of legal questions on this thing. And I don't know that the trial would be anywhere in sight, because we're going to spend quite a long time in preliminaries just trying to figure this shit out, trying to dissect all this stuff. So and by the time we're done, the election will probably be over. So incidentally, him being indicted and even convicted wouldn't preclude him from running for president, for what it's worth. All the requirements to run for president are mentioned in the Constitution. So even if they convict him, he could still run for president, which is also hilarious. So, yeah. I would also point out, obviously, that the legal ramifications are not the only ramifications that are in play. There are also political ramifications and practical ramifications. Political ramifications are at least proper in some sense to consider, because the prosecutor is a political official. All prosecutors are political officials. They're either elected or appointed, depending on the jurisdiction, but they're political in their nature. Prosecutors have prosecutorial discretion. They have the right to not bring charges. Some of the reason that they do bring charges or don't bring charges are for political reasons. If a community is particularly outraged about a particular crime or series of crimes, they might really, hammer those particular crimes, for example, because the community is particularly outraged. So there is an inherently political component to the prosecutor's decision to prosecute. And this is obviously a political figure, former president of the United States. It's hard to be much more a political figure than that. So one of the problems is the political aspect of it, because if the case winds up being as shaky as I've sort of outlined, based on the information that's available, and maybe when we get more information, it will seem less shaky. But if it winds up being as shaky as we've outlined, this looks like political retribution. Of course, it doesn't particularly help that a lot of people who have been running for prosecutor have openly said, yes, I'm running to be prosecutor to put Donald Trump in jail. So it doesn't particularly help that there's a lot of statements out there that make this seem very overtly political. So, if you decide to bring this case on the weak grounds it seems to be bringing, the political repercussions of this are very severe, or could be very severe, and I don't know why you would do that, because it would just increase divisiveness. And then, of course, there's practical and pragmatic repercussions, because you have Donald Trump, who is running for office, and it looks like this could look like interference in the election in and of itself by New York, trying to interfere with the election. So the very thing that they're accusing him of, essentially, which is a campaign finance violation, like you're trying to manipulate the books of your campaign finance, so it wouldn't be listed as a campaign expense. So you're trying to manipulate the campaign to put yourself in a better looking posture to manipulate the election. The fundamental thing they're trying to accuse him of would be basically the thing that they're doing. It's like, we're trying to manipulate the perception of Trump in order to do this. So I have a lot of doubts. He cannot pardon himself, Sarah. This is state level offenses, not federal. So pardoning himself is out. I'll answer some other questions for a moment or two, and then I'll sign off. By the way, thanks to everyone who was trying to cheer me up yesterday. I appreciated it. I appreciated how many of you were very, very nice to me in chat. Trump is soaring in the polls, yeah. I think this will just wind up creating more blowback. I think this will wind up creating more blowback than I think it's a mistake. What happens if Texas tries to indict Biden? On what basis would Texas indict Biden? You'd have to find some sort of jurisdictional hook. What would that be? You can't just indict him for the hell of it. You have to find a jurisdictional hook. What would Texas's cause of action be? Was the reason for statute of limitations? The idea being that, memories fade. Memories fade, and so the evidence the quality of evidence becomes poor by just active attrition. And so after a while, it's just, memories fade and witnesses move, and it just becomes implausible. I think that's the reason for statute of limitations. Same basis as New York is indicting Trump. I don't see that. I mean, you'd have to find a campaign finance violation the Biden team committed in Texas, or what would the campaign finance violation be? I mean, you can't just make shit up. I don't know what you would indict him for. I'm being too literal? Okay. Noted. I mean, I don't know. I'm just reading the words. I mean, someone said the same thing. So I was like, okay, well, I don't know what that would be. Would this prosecution, if successful, have a chilling effect on mediation with businesses in regards to payouts and NDAs? Probably not, because if it's really the business's liability, then it should be on the business's books. So I don't think so. I think the point is that indicting Trump creates a strong incentive for Republicans to start doing the same, right? Yes, that much is true. Yeah, that much is true. You know, if, you know, once you break the dam one way, it goes the other way. Is the only charge the giving money to a prostitute to stay quiet? No, that is not the charge. Saying this is a campaign violation? Yes, that's the problem. Explain for a silly British viewer. I have been explaining it. I'm not sure how much better I could be explaining it than I already have. It's like the idea is that this really is a campaign expense that was listed as a personal expense. And so that's a campaign finance violation. Of course, it's worthy of noting that assuming that he had listed it as a campaign finance expenditure, that New York could be making the argument the other way around, right? If he had listed it as a campaign expense, then New York would be in the position to saying, this isn't really a campaign expense, it's really a personal expense. And so you committed the fraud by putting it as a campaign expense when it's really a personal expense. So if Trump had done it the other way around, New York would be able to charge him under the exact same theory reversed, which is also pretty messed up. You listed this as a personal expense. It's really a campaign expense. Oh, what do you mean you listed it as a campaign expense? It's really a personal expense. Yeah. Fraud is kind of the idea. Sort of. Yeah. So like you're keeping things off the books in order to make the campaign look a different way. So sort of, yeah, kind of fraud idea. Yeah. Is that what happened to John Edwards? A very similar thing happened to John Edwards, although the evidentiary picture against John Edwards was obviously a lot different. So, you know, every case has to be assessed onto its own terms. But yeah, the evidentiary picture for Edwards, it was similar. But of course, the details are what matters when you're looking at legal analysis. And Edwards was acquitted. That too. When does a misdemeanor ever become a felony? That happens all the time. There are a lot of misdemeanors that become felonies. Sometimes it's because it's a subsequent offense. So sometimes, like the first time you do it, it's a misdemeanor, and the second time you do it, it's a felony. Or another good one where a misdemeanor turns into a felony is like for theft of goods. Usually the threshold is $500 or $750, something like that. But if you steal less than like $500, it's usually a misdemeanor, and steal more than that, it's a felony. So misdemeanors turn into felonies quite frequently for aggravating factors. All right. Can I do a TLDR? I'm not sure how I could summarize it any faster than I have. They're trying to bring him under some idea of campaign finance violations that are based on federal law violations that New York wants to argue in and of themselves are New York violations that are relating to him listing an expenditure as a personal expense when it was really a campaign expense, and that Trump knew about that. I'm not sure how much shorter I can do TLDR than that. How viable is the charge? I don't think it's very viable given what I know. It seems very tenuous. Do you think that all people that legit do these acts and there are crimes should be punished through the legal system? Well, I don't know the way that you phrase the question. I'd have to say no. It depends on what the evidence is. I don't think prosecutors should bring shit cases. So the way you ask the question, do I think all people that legit do these acts and are crimes should be punished? Well, no, I don't think that, because that would mean how do you want me to interpret your question? I'm going to interpret it literally. I'm going to interpret it the way that you phrased it. So I'll interpret it literally. Do I think all people that legit do these acts and there are crimes should be punished? No. Because that would mean that the prosecutor should bring cases even if there's not evidence, because the people are in fact really guilty. It's an invitation to abuse by prosecutors. So I think that you should only be, I think that the only people that should be brought before the court are people where the evidence is enough to sustain a conviction. So I'd have to say no to the question the way you phrased it. Sorry if that's too literal. Have I read 3 Felonies a Day? Oh, sure. Great book. Recommended. Is a motion to dismiss actually viable, not just theater? A motion to dismiss in this case would be viable in an indictment because the underlying legal theory is problematic. Hey, someone bought one of our merch. Someone bought a woman's V-neck embroidery logo. Kick ass. I hope you enjoy the merch. Okay, well, I guess that'll bring us to the end of the stream since there doesn't seem to be any questions. If you've enjoyed this stream, I hope you will remember to give it a like. It really does help the algorithm grow. I really appreciate everyone's support of this channel and of me personally. It really does help on days where, you know, things are not going as well as I would like, where I have problems, where the screen is just purple for no particular reason, and the frustration becomes very, very real. If you've enjoyed the stream, I hope to see you on the next stream. We may do Twitter today. I was thinking about potentially doing Twitter oral argument today. This afternoon, maybe. We'll see. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.